Hello, good evening. Am I audible?
Yes, sir.
Thank you.
Hello. Hi, sir. I
So,
am.
yes, Dr. Sachin, welcome, welcome.
Oh,
Thank you for joining.
thank you. Thank you so much.
I made
So,
you co-host. You can check.
okay.
We're starting at 7 o'clock. Participants are joining.
Sure, sure. So, in meanwhile, I'll share the PPT.
Yeah, sure, sure.
So, can you please confirm whether PPT is visible? So, Dr. Kalpesh, I believe PPT is visible.
Not now. Let's give you the WebEx screen. You have to select PPT.
Okay, oh, let me check because I did this select share window. So, let me check once again. I'm clicking here on share. It shows Chrome window and entire screen. Three options. So should I select
Go for
entire screen?
entire screen. Yeah, entire and slideshow mode.
Okay. Now,
Yes, visible. Yeah, slide number two.
okay,
One. Yeah.
one. Okay.
Good evening, everyone. I am Shubhra Singh, Assistant Professor, Sage University, Bhopal, moderator for the third day capacity building program. On this day, we are honored to have Dr. Sachin Sharma, Associate Professor of Law at Himachal Pradesh National Law University, sharing his expertise with us. His research areas include philosophy, disability jurisprudence, healthcare, and gender sexuality studies, with a particular focus on legal theory and public law. He has taught various subjects, including law and weaker sections, law and poverty development, jurisprudence, law of tort, interpretation, and constitutional studies. Dr. Sharma is associated with Action Research in Disability Studies. Let's welcome Dr. Sharma and hear his insights on the topic Rights of Disability Act 2016. Over to you, sir.
Okay. Thank you. Thank you so much, ma'am, for your warm introduction. So now I'm only able to see the screen, this PPT. So anyways, so we'll start. So as the topic assigned to me is related to Person with Disability Act. So what I did is that I will be particularly concentrating at Chapter 5 of PWD Act because it talks about the healthcare, social security, so on and so forth. So, but I'll not be going into much about the the language of their language of the act or legislation. Instead, I have designed or prepared a more uh, we can say a question based approach, a kind of where I'm looking at the entire law from a very critical lens, questioning the whole deliberation which has been dealt through these particular sections or these particular provisions. Okay, so this is what I'll be planning to do, and being inclined towards a theory or towards having that theoretical background. So the major discourse will be based on that theoretical literature supporting on that. So, when we talk about disability, and it is your third lecture, so I have gone through the schedule, and already you have talked about disability, the types of disabilities, and general about the legislation, act, and other things, the growth, development of it. But when we talk about this term disability, for me, it's first important task, to question this expression. So are we able to question this entire expression, the whole terminology or that expression, that what does this disability mean? So does it mean something called impairment, you know but then how do we define that impairment? You have already discussed these things when you have talked about the model of disability, that medical model and many other those models, or whether it is something, some the conditioning, like how do we define it? So first and foremost question is that whether disability, the definition of disability, be in the Act of 2016 or under UNCRPD, whether this definition is or expression is independent, or whether it has influence of that ableist notion, or for that matter, that eugenic thinking. So where you believe something as abled, and then automatically you construct a binary called something as disabled. So this is the first fundamental question from that social linguistic studies point of view, that how this term disability has been contextualized or has been understood by all of us. So is this about a difference? Can we say so? Because when we say disability, and particularly people who are working in the field, and people with disability, for us, like, we believe that disability is a diversity, primarily, and of course having certain differences. The differences as in term of, my way of doing things, but that does not mean vulnerability. So that is the point I am writing here, that it leads to construction of vulnerability. So our fundamental question is that whether the legislation, this Act of 2016, has helped us understanding disability from an independent lens, or does it interpreting or understanding this entire discourse or expression from a lens of that ableist society? So that is the first and foremost question. So is it about certain standardized patterns that we are talking about? For instance, when we talk about education, when we talk about employment, when we talk about any such other right or any such other, idea or aspect. So is this some sort of standard we are looking at? So when I say that I have a right to equal education or equality to have education, so in what context are we defining so that expression called equality this within the parameter of that disability law? So that first fundamental question. So for me, the existing discourse, the existing law is ultimately a normalized structure. When I say normalized, it means this kind of a conditioning, that parameter, the standardization, it's been fixed by someone. So for instance, for me as a person with disability, to get any assistance, firstly I need to produce that certification, the document. So my identity is subjected to, or limited to that certification. So in that sense, you have fixed a standard, a pattern. And if I'm not qualifying, or if I'm not getting that access to have that certification, then I'll not be considered as person with disability, or I'll be not entitled to all those, those social securities or assistance which are being there by the constitution provided to me, or by any other law for the time being. No, so this is something which I believe is very, very fundamental question. Because why I'm raising this question? Because still, even though we claim that after 2016 law, there have been a lot of changes in terms of disability or identifying people with disability, but still there is a large section of society or people, with disability, who are still unable to, or are not able to access that certification process due to various reasons. So there are a lot of independent research and data available on that. And this is particularly I'm highlighting about the places, particularly the rural areas, or which some geographically tough places like some hilly states, etc. So what happens is that when we come up with a law, it talks about some sort of segregation, and which ultimately leads to dominance and control. I don't know how many of you have gone through the bare language of the act itself. So there are so many provisions, that gives you a narrative or a sound of that someone will be doing it for someone. Okay, it's not about nothing about us without us. This is the primary slogan on which the disability laws were designed or deliberated. But ultimately, when we see the text, so it sounds something different. So there is this continuation othering, okay, and which is because of the institutionalized discourse. When I'm saying institutionalized, means the system, they created the discourse. So they defined, the system defines, okay, what is reasonable accommodation. For example, when we'll be reading the section, like for example, the Social Security section 4 of the Act. If you read the opening line, it says it is the duty or the obligation of the state to provide so and so, subject to its economic condition or capacity. And there are various examples, where state can easily take that plea that it is not within their economic, capabilities or so-called capacities. So henceforth, that reasonable accommodation is as per their understanding. It's not as per the understanding of a person with disability. So for instance, when I ask for reasonable accommodation, and it talks about that you have, this right, reasonable accessibility, but who is deciding it? Let's take this straightforward example. You see the example of accessible building, accessibility all around. So it talks about that there must be ramp. So just to fill in the blank, fill in these documents, you construct in these buildings, people construct ramps, but many times they are ignorant about the angle, that how tilted it should be. Can a person with disability on wheelchair can easily and independently use that ramp, or whether it is otherwise. So no one is taking into those considerations. So in fact, there are a lot of litigation on that particular issue as well, so where people have questioned that you have framed or developed this ramp, but which is not of any use. So this is called a pattern of standardization, and this is because of lack of sensitivity, and ultimately it trap us in a particular system. So if I am unable to get in or get fit into that system, I'll not be having my rights. So this is something, very, very important. And as a student of philosophy, I believe that, we need to think on these fundamental questions while reading or while, deliberating about the disability laws and the so-called related policies. So this is the first argument with which I'll be starting, and I am backing this whole argument on the basis of various literature and lot of writings. So if you see the entire discourse, the way this othering take place, so you can see the literature on religion and culture in context of disability. So it says that a person with disability is lack of completeness, and he's having some those sort of demonic influences and so on and so forth. Same talk about the medicine and disability, or the medical sciences. It again talked about a disabled person or disabled body as uncorrected body, less incomplete or inferior, which ultimately leads to inferiority of personhood, inferiority of citizenry rights. Even if today when we talk about we the people in our preamble, but you see the entire constitution, you nowhere you're going to find a disabled person or disability word has been used. Though we talk about affirmative action, though we interpret it as that it includes people with disability, but this is the argument since beginning when we talk about feminist, you know, jurisprudence or feminist argument. So that time also the idea was that you are saying that the women are included in your definition, but we want a specific, you know, expression within the text of law, so that we can give a more emphasis to that. But on the other hand, till now, there are, I guess, only in Article 46 or somewhere there is a term disability or disabled person is used. That is again in context of DPSPs, but not otherwise. The point is that if you see the background of literature or this relationship of law with other, literature, be it medicine, be it medical sciences or other, it gives you a very clear indicators, and that is evident from the the statistics of labor market. You see the ratio of employment of people with disability. It's rare, it's very on the very negligible end. You forget about other things, like we are working in law universities, law schools, and you see the implementation of roster and accommodation of people with disability within that roster. There are rarely few law schools or universities where people with disabilities are being getting or being provided employment at both at teaching and administrative level. So this is the problem, that this othering is continuing. So my question is that whether the law has helped us to dilute this othering. So I say that this otherization of disabilities continues. It's like we and other. So we could be, or I could be, you can say it as a state, it could be any agency or any organization, anything, or so-called normal people, anyone. And that other is always be like for me. In fact, very often I heard people saying, and very commonly, that we should do something for them. They need this, they need empathy, they need blah 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 thing. You see the way this categorization of or the choice of our language, the words, and it is not our fault. It's like this programming, that we have gone throughout these many stages. So this is what these models, these models leads to talk about, that it talks about the growth of a discourse, of course, from that charity till the human rights aspect. But questions still remain that whether this human rights approach or a human rights model, does it is reflected in the laws, or whether it has been implemented through these laws. So that is the idea, because you see till today the Contract Act, I'm forgetting which section, I believe section 12, it says that person with unsound mind cannot enter into a contract, in our Indian Contract Act law, if you see. Similarly, there are many other such laws. So, you see how strange it is that for a idol, for a non-living body or entity, you have the status of personhood, but for a person with mental disabilities or socio-psycho disabilities, you don't have that status of person. They can't contract. So this leads us to the question that where are we? What is the contribution of these laws? So what are we glorifying? So or are we doing or going in a right direction? So what happened is that till today, the construction of disability is within that idea of vulnerability. So it's always like majority. Though of course, scenario is changing, things are changing. Like a few days earlier, I was delivering a talk at some other place, so speaking particularly about the cinema and disability, so there I was telling them, particularly Indian cinema, that how earlier Indian cinema used to represent disability, particularly dwarfism and other related, you know, disabilities, and now how things have been gradually getting changed, but of course at very slow pace. So this vulnerability wala factor is still continuing, because we always believe in that sort of normality, normal. We always say this is the normal thing, and ultimately this notion of dependency and stigmatization is still persisting, in our society, despite having laws, different legal provisions, So I call this the entire process as a consumerism of disability. That I always tell often in my classes that this is the time that where our body, soul, mind have been hijacked, as in that everything has been consumed for some other benefit, someone else's benefit, and there is this whole body politics, you know so and that politics is everywhere. It is there in our social reviews, it is there in our cultural reviews, it is there in our legal domains or expressions. So this politicization of disability or the laws related to disabilities, it ultimately leads to problem, because we still interpret, consider difference as incompleteness. So there is this very interesting work, Race in the Bottle, by this Jonathan Khan. If you read that work, there he says that how this literature is particularly about race, that we give superiority to A race over B race, and that notion is still continuing despite all changes, all laws. We have 14th constitutional amendment to United States in Bill of Rights, sorry, that 14th Bill of Rights and even due process clause, but still that expression is there, and in our law, what we follow when we talk about disability, we follow this best interest theory, so it is the best interest of a person, and that's why people are interpreting, courts are interpreting. There are multiple judgments. I can name at least one, like Suchitra Srivastav and versus Chandigarh administration. So I don't know whether it is Chandigarh administration versus Suchitra Srivastav. Earlier it was there in High Court, and at Supreme Court it became Suchitra Srivastav versus Chandigarh administration. I guess I'm forgetting the year. You can check. But this case tells us this best interest theory that where court interpreted that a woman with socio-psycho disability, with mental disability, who was sexually assaulted by a person, or some sort of caretaker of a rehabilitation center where she was residing in, and gradually she got pregnant, and at very advanced stage of her pregnancy, this factor came to the knowledge of the concerned institution, and they tried for abortion. So they constituted medical board, they approached the High Court. Everyone is saying yes, she should go for abortion because of her disability, she can't take care of the baby, so it is the best interest. So their court inserted this provision, in the interest, as a guardian, we are interpreting this, but against the will and preference theory. No one has provided that supportive mechanism, where you can deliberate, you can tell, or support or assist the concerned individual and try to know his or her will about the same. So idea is there need to have a paradigm shift from best interest to the will and preference model. It's my will, it's my preference. Concerned about that, or are we concerned? It is in your interest. It is in the interest. So there is this dominant versus subordinate group. So this ultimately becomes to this kind of category. That dominating group is always the that best interest group where others are interpreting, and subordinate group will be form of the person with disability. So there is this continuous subject object dichotomy, what Michel Foucault says, that you don't give this, you work this power under this power dynamics, power structure, so where the one who has that apparatus of power is the other individual, whom I am narrating as third person narrative, and the weaker or subordinate group is always the first person. So first person means I as a person with disability. Third person means anyone else who are talking on behalf of me. So this whole monologue to dialogue is somewhere problematic. So though after UNCRPD, when UNCRPD was constituted or framed, so it talks about that people with disability must be on the board for any such deliberation. But when we see in practice, in actuality, so it's like there is just a tokenism sort of thing, just एक photo खींचने के लिए representation, but in actuality things were very works other way around. And I have such an experience being, uh, like as a scholar working at the Nalsa Center for Disability Studies when this law was, the first draft of the bill was framed, designed. The bill, what was drafted by the center there under the chairmanship of Professor Dhanda, and the ultimate final law which came into existence later, at very later stage. So totally, a lot of differences are there. So that is the point, that law requires nothing about us without us. So particularly when we see this idea, but in theory and practice, things are very different. So still we don't have that, inclusion model. So if I particularly talk to you about social security, the section 24 of the law, I'm reading it from here, from a Bare Act. So it says that appropriate government shall, within the limit of its economic capacity. So this is the point I was telling initially, that within the limits of its economic capacity and development, formulate necessary schemes and programs. You see, आपने सबसे पहले ही अपने हिसाब से एक लिमिट लगा दिया, एक प्रोवाइजो लगा दिया. So if you don't have that economic capacity, you can't. So I earlier used to write to various, आपके जो subjective departments, for example, transportation department or many other departments. So I used to get these, not a written reply, but at least in conversation, they used to admit we don't think, like once I gave a proposal for low floor buses in Himachal, but when I had that conversation, it says कि it's not economically feasible for us. So the reply was something very weird. They say we already provide a pass, to free service, free transportation to people with disability in the state itself. So, and what else you are expecting, But you see, but if I'm unable to access that bus, if I can't board that bus, उस pass का फिर मैं करूँगा क्या? What I'll be doing of that, that kind of document. So this is what the problem is. So it talks about these ideas. So it further says that the appropriate government, while devising these schemes and programs, shall give due consideration to disability and so on and so forth. And it further talks about, so I don't think there is any point for me to read out these provisions. You can read it your own self. It talks about facilities for persons, including children with disability, or support for the women with disability for livelihood, access to safe drinking water, and all those things. But about actual situation देखते हो तो things are very adverse. We all have witnessed COVID time. You see the position of certain quarantine places where people with disability were quarantined, under quarantine. They didn't have that basic facilities. You take the example of आपका demonetization when there was this change, so उसमें like once this order came, उसके next day or later, policy for or directions for people with disability came. So earlier it was not there. Then there used to be huge queue at the ATM. There is not even a single like at least the places where I was there at that point of time, any disable friendly ATM machine. Even till today, rarely you'll find these disable friendly ATMs. You know, now people may say, now we have this Google Pay and all, but no one, everyone is not using it. For that matter, till today I never use these online, this Google Pay or Paytm kind of thing. I always carry my ATM if I have to, or otherwise with cash. So point is that these things are there, though it talks about these parameters, these things, but in actuality it's rarely there. So to talk about access to safe drinking water, and sanitation facilities for women with disabilities. Still, there are a lot of lacking. Then the next particular provision is about health right or health care, which include reproductive rights. So there are like very less awareness among women with disability in regard to their reproductive health, or choices as compared to general women. And for example, when we talk about the rural women, the percentile is less. But then when we more specifically talk about women with disability in that rural area, you rarely gonna find people having the proper awareness, knowledge about their rights, their accessibility related things. So that is the idea that the law on paper, it talks about things. It talks about provisions of aid and appliances, for example, wheelchairs for people with physical disabilities or such kind of appliances. But the factual scenario is very difficult. You know, I recommend you to watch that documentary. It is a official documentary on accessibility. I'm forgetting exact title, but if you check this on YouTube, you'll find it. So it says that even in places where you have a kacha rasta, you don't have a proper road or way, how you'll be using your wheelchair. You know? So particularly in rural areas, and in fact in many places like hill states like Shimla. So Shimla is one of the famous destination or a tourist destination. But if you go to this most popular place, the Mall Road of Shimla, not even a single restaurant, as per my knowledge, or showroom or any such shop is, freely accessible. In everywhere, at least in 98% or 95% of showrooms, restaurants, you have a stairs, you have at least a step. So where as a person on a wheelchair, you cannot access. You need someone's help. In fact, we earlier through our center we conducted a survey. So where I was sitting on a wheelchair and someone was taking me, and we talked to the managers and others. So they say कि इनके लिए हम यहाँ पे ही order लेके आ जाते हैं. We can provide him that whatever he wants here, but we can't have access of wheelchair. So this is a place which is one of known as the most, like posh place, where if it is known in the world, still that place doesn't have equal and full accessibility. And then what about the other places? So same is the situation in many other scenarios. Even in recently I visited Delhi. So still many places didn't have that free access. Barrier free access. Still, though of course things are getting better, but still will have those issues. So that is the point. So it further talks about unemployment. In social security, it talks about unemployment. So as I have already told you that it says that unemployment allowances should be provided to people with disabilities, and there must be special employment exchanges for people with disabilities and all those things. But in actuality, like the growth, the development is still on a very slow pace. So that is the notion. When we talk about healthcare, healthcare is again one of the very fundamental requirement for us as a human being, and as a people with disability, we may need more continuous, persistent health facilities, healthcare. So it is not related only to the disability, but other wise also. But if that healthcare accessibility is not, barrier free, you'll have no other choices. So I don't know how many of you have that experience of government hospitals, the state run government hospitals, the kind of crowd they entertain throughout the day. It's difficult, even to stand in queue, you know. So in our state, recently, just I guess 2 years ago or 3 years ago, we have this AIMS. It got started. So I visited that hospital few days ago. There is a huge queue, and there is no particular, a place or dedicated, you know, section for people with disability. So you have to stand in the queue. You have to request someone. So if you will be requesting the security guard or someone might assist or help you in getting that prescription document or any such thing quicker. But otherwise, you don't have that space where you can freely, without that sort of dependency, where you can work. You know. So though it talks about Section 25 that appropriate government and other local authorities must provide free healthcare in the vicinity, barrier-free access, and provide priority in attendance and treatment. So in तीनों the provisions, the parameters, I never found in particularly the government hospitals. I'm not talking about private setups. In private you pay, you get service, but in government service, in government hospitals, it's very difficult. So here we have here in Shimla, the IGMC, Indira Gandhi Medical College. It's impossible for a person on a wheelchair or having any disability to get done his things barrier freely. Not possible at all. Same is this PGI Chandigarh. I'm talking about these are the prestigious, medical institutions of at least North India, be it AIMS in Delhi or these places. So you need at the end of the day some sort of dependency, someone to take care of. So, and the promise which we did, the commitment while signing UNCRPD on that it should be barrier free, though we are writing in our text, in law, our laws, but in practice, it is still, problematic. We need to work very, very hard. So of course, now there are a lot of discourse on making things accessible, particularly after this Justice Chandrachud judgment in, I guess, November 2024 in Rajiv Rathori's case, where he says that, you need to make the things accessible. So be it healthcare, be it employment, be it education or any such thing. But it will gonna take time, now, and ultimately and most importantly, it requires a political willingness, So we always talk about judicial willingness or judicial activism, but I believe in order to make the disability law a real success, we need to have a legislative activism, that where we really and make those policies and implement those policies at without any such hesitation or any consideration of that vote bank. So that is not the idea. So idea is about inclusion, but do we really have inclusive environment, inclusive society? You talk about education, you talk about employment, you talk about any other social rights, cultural rights, family rights, or related things. Do we have inclusive model? It's not. It's you see this new education policy or national education policy. It talks about disability, but it is not very open or pro about the inclusive disability. Inclusive education in that sense. Still, we have practice of special schools and other things. So there is that lack of inclusion, and if there is this lack of inclusion, it will lead to such kind of problem, such kind of idea. So that is the notion. That is what your the provision says something, but in actuality, in implementing them, it works other way around. So within the preview of this healthcare or health right to health under section 25, it talks about the government responsibility, talks about that it need to undertake surveys, investigation, research, and other things, promote various methods for preventing disabilities and provide training to the staff of public health centers, the staff of public health centers. So this is again very important thing, because whatever experience I have till now, I found medical practitioners very insensitive of people with disability, and like I had first-hand experiences, many such first-hand experiences where I found it's very demeaning. In fact, there used to be a time, there used to be a situation where I have to complain against a particular, senior doctor, against him, his behavior or his way of treating me to the medical council of that particular state. So that is again there at the point of sensitivity, the training program particularly. So when we talk about sensitivity issue, I found almost same, like rare exceptions are there in medical structure or system, as well as in legal field, in judiciary, lack of that sensitivity. So that is there all across. So it talks about that you need to create awareness to masses through. Am I audible now? Anyone can speak, because I can't
Yes, we are
see the
audible.
message.
Audible.
Okay, thank you. So that is the idea, that is the thing. See, so once we have these practices, it talks about that you need to create such awareness through television, through radio, through other mass media, through social media platforms. We can include that. This section 25 clause 2 subclause, I guess, H or somewhat, there is this particular clause. It talks about that use of these media, H, yes, of course, talks about awareness about health facilities, healthcare. But you see how much accessible are these media platforms? I guess on Doordarshan, I saw the sign language interpreter where I guess in morning news, there is this 5 minute or 10 minute news. So in all other these private news channels, you may correct me if I'm wrong, but I never saw a sign language interpreter, you know. So when this COVID happened, when any natural disaster happened, any direction or directives coming from the government, rarely people are able to know, you know. So people, particularly with the hearing and speaking diversities. So it tells us that how things have been done. And when we talk about social media, you can see your own that how many internet websites, institutions, websites follow the accessibility guidelines, the digital accessibility guidelines that, it tells us that they need to have a particular speed, the kind of information if it is flashing over their screen, on that website, or the kind of combination they use, the flash it games. All things are very, very sensitive, it triggers the condition of a particular individual having some sort of, disability. But are we really concerned about these things? It is not. So on paper, we have written things, but in actuality, things are very different, so that's the point. So like many times people ask me, okay, these are the issues, then how we can, come to the solution. So I always say it's only and only through making ourselves sensitive, you know so where we can connect to the other individual without explanation, without him being the problem, so that needs to be the case. And this is what David Hume or even Adam Smith in his work, used to talk about. He uses the term judicious spectator, where he can enter into the shoe of others just without giving, and or getting any particular request, but your own, just so that is the approach. So, and that makes the difference. This is the only way we can make the difference. Similarly, if you talk about Section 26, because it again includes within the ambit of Social Security, it talks about insurance schemes. So already there are a lot of research going on, and I'm aware that the Dr. Mary Sport, at GNLU, he is conducting that research on accessibility of insurance schemes and policies. So there are differences, so that these accessibility or access to insurance schemes for people with disabilities, particularly healthcare schemes, are very difficult, and very costly. So that itself still is the case. You don't have that open advertisements for insurance schemes for people with disabilities. But otherwise, you have thousands of advertisements throughout, running on your screen, on your messages, on your cell phone, and other places. Then if we come to rehabilitation, so it again says that the appropriate government or any such local authority shall, within their, again it says, within its economic capacity and development, undertake or make such arrangements related to the rehabilitation, particularly in the area of health, education, employment. So I already told you that the situation on the practical side or the real side, or the situation on the theoretical side. So that's why in the very first line of this slide I'm writing, in theory and practice of inclusion. We need to bring theory and practice together, and if we are not able to bring that, then it will not going to make the difference. So it's about that disability rights, but not rights as being defined or provided through these legislation, but rights in action. So this is the time where we need to speak, or we need to demand, or we need to assert about our rights in action. Okay, that in action are how far they are working. So that is the whole point. What Gayatri Spivak says, that can a subaltern speak? So when we talk about people with disabilities or disability laws, the question is that is really a person with disability has the voice, a common person with disability of the country having that voice, or is it is still being otherized or controlled or dominated? So that is what we need to understand. And it's not about, the issue is not related to that related to the old time or this coming generation or new time. I saw the problem, the stereotyping, it is more there among the younger generation. So every year as an academician, I meet a new bunch of students, new youngsters, and every year I got these complaints from the students with disability on campus that they feel, discriminated. Many times the roommate, they refuse to share room with them because they need some sort of assistance sometimes or any other things, So they never have any socialized structure or circle within the campus, So it's very disturbing. And in fact, I did counseling to many students at my previous institution at RGNUL, or earlier at Assam, and now it's here, where people are getting into the depression because of the behavior, the treatment of, you know. So so the point is, it's not the age or the old people or the young people, but this is something related to that psychology and that stereotyping. Still it is continuing. So point is that whether laws are able to dilute this stereotyping or not, because what we expect from any state or state responsibility, if you see, I'm explaining this in context of that social security or that model, so what basic things you required this five basic things. It includes physical assets, it includes human assets, social asset, environmental or ecological asset, or existential asset. So in physical asset, you talks about that physical infrastructure, basic things. In human and social asset, you talks about the conditions, the equitable conditions of living, as along with the social conditioning, social recognition, inclusion, and accessible environment, equitable and accessible environment. So that, and existentialist asset means that you have the the space to connect to your own individuality. So you should not be influenced, always be getting influenced by the outside, you know experiences or outside world. So for example, if someone asks me that, are you don't you feel something, less about your body? So I always say, it's never be the case. I never ever think in that manner. So that is about that your own connection to your own self, that existentialist, about recognizing of your beingness. you know so as a being, I am connected to myself. Do I have that space? So that is more of a philosophical, and other elements are more of a materialistic, if you want to classify this in that line. So the law, for me, the analysis of person with disability act is that, where we categorize it, does it helping us in making a physical asset accessible, human asset accessible, or any other kind of asset? So this is what we need to think about. So it's about the inclusion, it's about the completeness. But the problem remains this, that we consider disability from that medicalization, from that prejudices, some sort of cure mechanism. you know and accordingly we constitute our laws, our policies. So there is this International Journal of Disability and Society. I found in one of the paper, I'm forgetting to mention the title here, and in some other places as well, in the definition of disability, it says that disability is a pre-discursive, transcultural, and transhistorical disadvantage, an objective human defect. So this is what that stereotypical that you have perceived already. It could be non-accidental, it could be accidental, biological, human property attribute or characterized, that ought to be prevented, corrected, you know, so eliminated or cured. So this is the problem. This sounds like a medical model, that there is a problem that you need to cure it, or you need to eliminate it, you need to correct it. So this binary is still operationalized. It's still working in our discourses, and you construct that definition within this particular narrative. You gave it a name. So I am, asking all of you to think, can you replace the term disability with something else? Because the naming itself limits the expression. That's what this one of the very powerful book of Saul Ekripak, Naming and Necessity, there she says that how naming limit the expression. And interestingly, she gave there the example of Hitler. So she says that whenever we talk about this name Hitler, always and always you get that negative image, what he did during Holocaust. But as the childhood, his childhood, his how he was, what was his, those innocent expression. No one is never ever will get it. Even if you Google it, Hitler, you'll be getting the knowledge, description, information, all related to his the so-called bad deeds. So this is the problem with the name, that when you give a name to something, that expression, it limits that expression. So for us, the fundamental question is disability is derived from the ability? Because if you are admitting something as able, then only you are saying something as disabled. So can there be a discourse? I am not able to answer this question to you, but I want you to all to think about it. Can there be a possibility? Can we think of something? So that is the idea, because what happened is that we fix a teleology, purpose, through the name, through that discourse, that expression, and which ultimately construct the discourse. It is something very similar when we talk about Article 14 equality, in our constitution. But it nowhere talks about affirmative action ka formula. It says कि yes, you need to give, there shall not be any discrimination on the ground of race, caste, blah, all so and so forth things, But that the formula which we designed about reservation, that is our own creation. The constitution per se nowhere defines it or wrote about it, you know. But this is what I am saying. This is not a permanent solution, that formula. It is always a temporary solution. The point is, are we able to think of a permanent solution? Do the political willingness will be there, Okay, but because we think of every discourse within that interest cost, we do that SWOT analysis, strength, weakness, or that benefit analysis, and accordingly we design policies, accordingly we design laws. So then it leads to problems, So that is the idea, that there is always a possibility of mind getting influenced, or we getting influenced or impacted by the surroundings, So be it through that language, be it through any such discourse, any such policy, you get that understanding. We get that understanding, Like I did this through my research during my PhD research, when I was looking at the sexual rights of people with disabilities, including reproductive health rights, you know. So I found that there is this conditioning all across among the majority people with disabilities, as well as their parents or guardians, So they say that we just want a stable life, and even if we are not aspiring for any marriage or sexual rights or so and so forth, reproductive rights, so that conditioning is there, so and automatically society works in that way. We talk about free choice within the ambit of our article 19 of constitution, but do we really have free choice? Rarely, it's nowhere. You talk about compatibility model, compatibility. For example, if one is looking for a life partner, so there are rarest of rare examples where you will have a person with disability at one end and so-called person with ability at the another end, because otherwise the compatibility is always be suited within the able-bodied and within the disabled-bodied, not other way around, So this is what that wiring, that this conditioning that has been taking place. And at both the end, we believe, okay, this is the right thing. This is my free choice. So here, henceforth, I'm quoting here Dorothy Roberts, this line where she says that our brains are plastic with the ability to be modified by social experiences. So whatever experiences we are having, it is modifying our way of your decisions. So what we do, we generally create a situation, a situation where we say it is not accessible for people with disability, and henceforth we name it as a problem. This is a problem. This is impairment. This is lessness, incompleteness, and then you provide so-called your own solution. So this is the game. That's why in beginning earlier somewhere I talked about that this is the consumerization, that you made every expression a consumer setup, a economic benefit point of view. So there is always a power dominance in the discourse around the law, around the medicine. It's everywhere, So henceforth the need is a sensitization and a wider perspective, But that is very difficult, like every year, and so UGC come up with certain schemes for people with disability. If or many such bodies come with schemes for people with disabilities in general, but if you able to evaluate them in a sensitive manner, you found them very problematic, very difficult, in a sense that lack of sensitivity. Like that UGC example which I was mentioning there was related to, I guess, few years ago, I guess 2, 3 years ago, I believe, there was a proposal or a, advisory kind of thing or a notice from UGC to all educational institutions that if you have people with disability, make sure that they'll be sitting on the first row of the classroom. So if I'm a backbencher, I love sitting at back bench, or my friend is sitting there. I'm taking notes from his copy because I may have, visual diversity. But you are making me, you have to sit on the front row. So I saw in many places, in schools and places, the teachers are going and identifying students and asking them to come and sit on the front row, which is very, very demeaning and disturbing psychologically. So that's the point, that we have to exercise our autonomy, and our freedom. So the question is whether the law, the Person with Disability Act, or any other law, is helping us to exercise our autonomy in a free manner, in an independent manner. That is the idea. That is the question. Does it recognize our individuality, or our fundamental freedom, or it is still be depending or conditioned? So the answer is yes. We can do this through recognizing this universality, interdependence, and that kind of idea. So only then we can think of disability, because we always say that disability is an evolving concept. It's about the interaction person with impairment and the attitudinal environment barriers. So it's about more to do with the environmental barriers, the societal attitudinal barriers. So like I have a friend with visual diversity. He has very low vision. So yeah, he's my childhood friend. When he used to play cricket in our childhood, so he always used to do in fielding time, during doing fielding, he always used to stand behind, you know, there, behind the wicket. He always do that as a keeper keeping. So he just saw the ball and grab it. And so we never ever, none of us ever realized that he has some sort of difficulty in looking at things and or visibility issues. So at very later stage, because in classroom, when he's sitting with someone, he's taking the notes from the friend. So everything is like in very legitimate manner. But when he joined academic profession later and he gave interview somewhere, you know, and there he was pointed out that no, it is difficult. He gave interview. I will not name the institution, private, well reputed institution. He gave interview there, and his knowledge was there, fine, but they simply rejected him on the ground he that they feel that he can't control the students. This was long back, and this fellow, he never ever applied for disability certification or any such thing, because till very later stage he never thought like that there is a problem. It's like fine, the family never interpreted this in that manner, or he never told them that he's having any such difficulty. So these are examples. There are these sort of examples. So that's why that your attitudinal and environmental hindrances make our disability as a disability, and it has not with that of impairment or any issues with our body. So I'm not glorifying disability, but I'm telling you the factual scenario. So henceforth we need to think of our decision making capacities. So do the law provide that capabilities or capacity to all of us? Do we have these idea? So these are the things which I have explained already earlier, that will and preference and other issues. So though law laid down these obligations on the state in terms of awareness, accessibility, health, social security, rehabilitation, employment. But in actuality, are we able to make a difference? You know, so that is the notion, and how CRPD is working. You know, in fact, now there are a lot of literature coming up. Literature, it says that how do we CRPD now? You know, there is a committee reviewing state reports or third parties report, but you know, it talks about that we need to provide that capability approach, what Amrita Sen and Martha Nussbaum has introduced or articulated about. But in actuality, things remain problematic. So we, because we always believe that disabled person needs shelter, rehabilitation, welfare, impairment can foreclose legal capacity. So that ideological construction of disability through individualism and medicalization, you need to make these things clear, you know, that there is a equitable rehabilitation and dignified welfare and all. So henceforth we'll need for a paradigm shift. So I think now I should conclude that it's already 8. So now that is the point, that through this paradigm shift, we need to talk about the action-based right. You know, we need to talk about the, you know, that how exclusions are still continuing, how we can make a political participation for people with disability. So these are few examples I'm just highlighting. You talk about the already examples. So it says, you know, that the laws are there, but has its own limitation. You know? So I think this, with this last quote, I'll end. You know, so it says that this is Professor Gerard Quinn. You know, so in his this moral authority of change in human rights and disability, says that human dignity is the anchor norm of human rights. So each individual is deemed to be inestimable value, and nobody is insignificant. People are to be valued not just because they are economically or otherwise useful, but because of their inherent self-worth. So this is the point that of existentialism which I was talking about. You know, it's not about that utilization perspective, but it's about that inherent self-worth. So we should not think that, okay, well, how I am contributing or getting such benefit or doing benefit to someone, but it's about basic, you know, inherent self-worth. The human rights model henceforth focuses on the inherent dignity of human being, and subsequently, but not if necessary, on person's medical characteristics. It places the individual center stage in all decisions affecting him or her, and most importantly, locate the main problem outside the person and in society. You know, so that is the, so problem is not in me in as a person, but it is in the society. So this is what the approach of human rights model is. You know, so I think with this I'll conclude. So thank you so much. If you have any query, then now I can see the messages, like many of you have.
Participants,
So yeah.
if you have any doubts, you can drop your doubts here in the chat box directly.
There are some questions in the chat box. Can you throw some
Yeah,
light
if you
on PWD, on the DPTP Act?
on the
PWD
PWD and
DPTP Act, Data Protection, Data Privacy.
yeah. So that is again interesting that when we talk about, you know, so PWD Act, as I said, I was only talking about these because the topic assigned to me was related to health care, health, rehabilitation, and the social security, you know, provision. So in chapter 5 of the act, so I touched upon all those provisions, and you know, from that critical lens, that okay, what the textual language says and what are the scenarios or the situations which we are facing till now, till today. So Coming to the implementation part of the LECT or the legislation, as I again said already, that though the Person with Disability Act was constituted or formulated with this very noble idea of bringing people with disability in the discourse, in particular in terms of law and policy making, are concerned. But when we see the real implementation, and there we see the issues, and it seems that there is the lack of political willingness, and that's why courts, particularly Supreme Court, continuously, if you see from 2016 till 2024, 2025, that
Okay, sir. So the next question is, what is the scope of providing health insurance
the
facilities to PWDs?
yeah, I think there was slight breaking of voice. Can you please repeat?
Sure, sir. What is the scope of providing health insurance facilities to PWDs?
Okay. Yeah, scope, as I was just touching upon, I think Professor Mary Sport is here, so he'll be able to answer this more particularly as he's doing research on this. But as per my experience is concerned, the scope of PWD in terms of health insurance, I found there is a lack of accessibility, or very few schemes are there or insurance policies are there. Even if they are there, they are not as per that usual terms and conditions. Yeah.
Yeah, Sachin, if I may come, since you asked me.
Yeah, I want.
Hi.
Yes.
Yes. Actually, with regard to this question, there are two government schemes, Swarnamram and then Nirmaya. Nirmaya talks about autism spectrum and other things, but the coverage is very limited, 2 lakh for that. But if you look at those disabilities, 2 lakh is very, very minimum. That only
Sure.
cover about that disability related issues, no other claims. Let us say if I am suffering from some kind of disease along with autism, then that 2 lakh will not be suffice. Similarly, if you look at Swarnamram, it's mentioned RPWD, again income threshold. It may not available. As far as general insurance are concerned, health insurance, please remember, if you disclose your disability, it's a gone case. If your insurer or insurance agent are very, very familiar with you, you may get a policy at higher premium. Otherwise, you will not get a policy. Even if you get a policy, maximum coverage up to 5 lakh. I'm telling you 5 lakh, there is no claim bonus, or you can say that some kind of accidental floater. Those things are not at all possible. Right? With this, I'm stopping here. Okay, Sachin,
Yeah.
over to you.
Thank you so much, Dr. Mary Sport. So yeah, this is the scenario. So you'll have lack of that access to those common policies, or premium are higher and things like that. So in a one-liner, I will say, as what Sir said, that when we talk about the insurance schemes or policies, still they are not properly accessible. So I rarely found, even the state are starting up deliberating on these issues. Like on this, if anyone want to read, can see the model of Singapore. Like recently, I have did a small study. So they provide, the state facilitate these insurance mechanisms, these policies. So yeah, thank you.
Thank you, sir, for your enlightening lecture on the Rights of Persons with Disabilities Act 2016. We appreciate the time you took to share your knowledge with us and look forward to applying these learnings on our work. Your contribution to our capacity building program has been invaluable, and we are grateful for your participation. Once again, thank you so much, sir.
Yeah, thank you. So
Thank you.
I deliberately, I didn't focus at their provisions. I gave you more of a critical approach. So yeah, thank you so much.
Thank you.
And thanks to the organizers.
Thank you.
Particularly Kalpesh sir and Mary Sports sir. Yeah, thank you, sir.
Thank you, Kalpesh sir.
Thank you, Sachin sir.
Thank you. See you in next session. So next.
Yeah. Bye.